Do you see the board clearly? Right. The topic today we are going to start is statutory interpretation. For statutory interpretation, this chapter, I'll use this as a core textbook. The English Legal Process by Terence Inman. This is the main book I use. Okay. If you can, when you look at this, you look at chapter 4. Okay, chapter 4, you can write down chapter 4 of English Legal Process by Terence Inman. I mainly use this one, and if you start with the book, have a look at section 4.10. Okay, that is where I'll start dealing with it. Okay, chapter 4.10. Now, before I go into the details of statutory interpretation, I would like to go through a few basic stuff. Okay, for example, who made this? Who makes an act of parliament? Is the parliament, right? Now, when the parliament makes a law, statute, from there the law needs to be enforced. Okay, and it may be it goes to a court, in relation to different disputes. Okay, now the court interprets that statute. Okay, in the process of the dispute resolution. Now, when the court is interpreting it, it must remember some basic stuff. Okay, and that is where we need to understand the relationship between the court and the parliament. Okay, now, act of parliament made by the parliament, it is interpreted by court. So we have to understand the relationship between these two. What is the relationship between the parliament and the courts? Okay, what kind of relationship it is? Is the parliament more powerful than the court, or the court is more powerful than the parliament? That relationship must be defined first if we try to understand what is statutory interpretation. Okay, now under the constitutional arrangements of UK, parliament is the supreme body for making law. Now, if the parliament is the supreme body for making law, it means that nobody can go beyond the limits fixed by the parliament. Okay, and that limit, what we call that limit fixed by the parliament, can be regarded as what we call the intention of the parliament. Okay, so the courts, when interpreting the parliament, is limited by what we call the intention of parliament. Now, this is something we will find very important. Intention of parliament. This is the, what is it? This is the upper ceiling for the court. Can it go beyond it? Can it go beyond it? The answer is no, it can't go beyond it. It will have to remain within that limit. If it goes beyond that limit, then the judiciary is actually exceeding its territory, exceeding its power, which it is not allowed to do. Very clear? Okay. Now, question is, if the parliament, when the parliament makes an act of parliament, and when the judiciary is dealing with that act of parliament in a dispute, why does the judiciary need to interpret it? What is the need for it? Okay, why do we need it? Why do we need it? If I make the law, if I'm the parliament and I make the law, and you are the judiciary, you are dealing with that law in a dispute, then why do you need to interpret that law?
To give effect to a given circumstance.
And what else can be the reason?
To express the intention of the parliament behind the enactment of this.
Shouldn't the wording be clear to express the intention clearly? Sorry?
How should it be applied?
If the parliament gives guidelines, we need to interpret it.
And some laws are very vague. If
Okay.
they make it explicit, then there is no need of interpretation.
Okay, that means there are cases where things can be very clear in the statute. There are cases things may not be as clear as the first one. That means the wording, that means the language. Okay, it can be so vague, it can be unclear that the judges need to interpret it clearly for clarification. Okay, for application. Are we clear? Okay, so the problem can be at the drafting, at the drafting stage of the legislation. Okay, maybe the draftsman used a word which may have more than one meaning. Okay, a word which seemed okay to apply at the time of making the law, but maybe 20 years, 30 years later, it may have got different type of application. Okay, now with this change of time, with this very, multiple use of multiple meaning of words, what do we need? We need clarification. Okay, for example, you see, someone applied for housing. He's claiming that he is homeless. When asked, he said, "Well, where do you live?" He said, "Well, I live in a room." Okay, think about it. I'm claiming myself to be homeless, but I'm saying that I live in a room. Then he said, "Well, I live in a room where there is no cooking facilities. I live in a room, there is no washing facilities. I live in a room where I just go and sleep and keep my belongings. That's it." Now, question comes, a room without cooking facilities, without washing facilities, can it be called as a home? You see, that is where the judge needs to interpret the word. What is the meaning of home? You may think, in a normal situation, you may think, well, we know what is a home. It's a very normal word. It's a word which we use in day-to-day things. But in this particular scenario, when this student, this claimant is claiming that he is homeless because the place where he lives should not fall into the category of home. The judiciary now needs to play its role to define whether that can be regarded as a home or not. If the judge thinks that yes, it can be within the definition of home, then yes, the direction of the case goes in one way. If he thinks no, it is not, then the direction of the case goes to another way. So meaning of words can be very crucial, is very crucial, is very significant when the judge is giving dealing with the case. Okay, and that is where there is, the need for clarification, need for interpretation is so important. Are we clear? Okay, so you see, statutory interpretation, if you look at the chapter, statutory interpretation is actually, it's a way of determining the relationship between the two organs of the state. Who are those two organs? One is the legislature, and other one is the judiciary. Okay, it determines that relationship. Who is superior than the other? Parliament is more powerful than the judiciary. One makes the law and another one interprets the law, of course, administers the law, applies the law as they wish or according to the wish of the parliament, according to the intention of the parliament. That must be remembered. That is a key thing in statutory interpretation. Remember, okay, the the court interprets the statutes according to the intention of the parliament. If it exceeds that limit, if it goes beyond the limit of the intention of the parliament, what do you say?
It has exceeded the bound.
Yes, it has undermined the supremacy of the parliament. That is something you do not do. Are we clear?
Yes.
Why do we need statutory interpretation? Okay. Now, there is a difficulty here. The difficulty is related to intention of parliament. Think about it. One organ making the law and another organ, while interpreting the law, must remain within the intention of the parliament. It's like someone says something, I have to think about it, I have to explain that, knowing, or I have to understand what was the intention behind it. Okay, there is a gap, because if I say something, I can easily tell you what was my intention behind it. But if you say something, it is difficult for me to say what was your intention behind it. That means there is a gap, and which needs to be bridged, because we are talking about two different organs. Maybe Parliament has made a law back in 1940, and if the court in 2015 needs to interpret the law, the court today will have to find out the intention of the Parliament. What was the intention of the Parliament back in 1940? That may not be easy. Okay, so the court needs to apply, of course, the judiciary needs to be very creative. The court needs to apply certain things, need to follow certain rules, need to apply certain, I would say, more appropriately, certain instruments to find out, to apply its own creativity and to find out the intention of the Parliament. And at the same time, they have to find out the intention of the Parliament in such a way so that it does not lead to an absurd outcome or unjust outcome. That is something they need to do as well. Okay, because the ultimate objective of the judiciary is to ensure justice. Are we clear? So the court is not actually free to interpret whichever way it wishes. It has got certain bindings. It has got certain parameters, fixed around it, and it must remain within those parameters and then interpret the statute. And that is a huge difficulty for the court. Are we clear? Okay, right. Now, can you write down certain things? Let me just give you a bit of things for you to write, and then I'll go through it. Now, it's more like a guidance for you. How do you write down an introduction, or how do you actually prepare the introduction for statutory interpretation? Okay. Under the English legal system, the Parliament is the main body which is responsible for lawmaking. So the judiciary, as, subordinate to the parliament is responsible for the administration of the law made by the parliament and at the same time the judiciary is responsible for interpretation of laws within the intention of the parliament. This clearly defines the relationship between the parliament and the judiciary. Full stop. In the process of interpreting the statute, the judiciary finds it difficult to uncover the true intention of the parliament. In order to facilitate the courts to find out the intention of the parliament, English judges have applied three rules of interpretation. And those rules are literal rule, golden rule, and mischief rule. So three rules made by whom? Remember this. Do not make mistake here. Rules are not made by the parliament. The rules are made by whom? Made by the judges. To facilitate whom? To facilitate themselves. You see, why they facilitated them? So that they can find out the intention of the parliament. So laws made by the parliament, the courts are interpreting them and they must limit within the intention of the parliament. So to do that, judges actually themselves formulated these three rules: literal rule, golden rule, mischief rule. Now, why it is so important for us to remember this point, that the judges themselves have formulated these rules? It means if they have formulated these rules, that means what they can do, that they can actually play with it. You see, if this was imposed by the parliament, they had to follow the guidelines of the parliament. They did not have any other way. Now, as the rules are made by them, they can now play with it. That means there are lots of rooms for discretion. Okay, look, there is no hard and fast rule saying that you have to apply the literal rule first. If it doesn't go, then you apply the golden rule. If it doesn't go, you apply the mischief rule. There is nothing like that. Okay, the best way of understanding it is to think about three boxes. You just imagine three boxes. One box is literal rule, one box is golden rule, one box is mischief rule. You have your case, you fix it. You try to fit this in three boxes. Whichever fits the best, you apply that. Then we have to think about something else. We'll look at that. But this is how you can just imagine. Okay, you just imagine yourself, for your understanding, that let's try which one it fits best. Whichever it fits best, you apply it. So there is no hard and fast rule. It depends on whom. It will depend on the judge. And this is where we may face a question from statutory interpretation. About the character of the rules of interpretation. Are they very strict rules? Are they rules like rules of law? Or are they rules where there are a lot of rooms for discretion? Are they very objective things, or are they more like a very subjective things? Okay, can the judge or should the judge get out of his own personal feelings and apply it very objectively, or judges may reflect their own point of view when they are applying the rules of interpretation? The second one is more like, yeah, correct, I would say. There are examples where there are a lot of subjectivity in the application of the rules of interpretation. There are a lot of subjectivity. Okay, there are examples, even at the highest level of courts, where judges themselves, judges have disputed. There were division in terms of opinion. Someone said we should apply this rule. Maybe other two judges said we should apply the other. Okay, so that means there are division of opinion, which tells us that look, there is no hard and fast rule here. You do not have to apply the literal rule in all cases, not necessarily. Okay, so this tells us that literal rule, golden rule, mischief rule, although these are I would say more inappropriately called rules. Actually, they are not rules. They are more like techniques. Okay, they are more like instruments of interpretation, techniques of interpretation. Why? For what these techniques are used? These instruments are used. These instruments are used, or these techniques are used to uncover the intention of the parliament. Who actually formulated them? It is the judges themselves. Whose benefit? For their own benefit, so that life becomes easier for them while interpreting the statutes. Okay. Therefore, there are plenty of rules of applying the discretion to uncover the intention of the parliament, to apply the rules of interpretation. Are we clear? Okay. Now, Literal rule, I'll just go through it quickly, what these are, go into the details later in our next class. Literal rule is very simple. You look at the dictionary meaning of words. Which dictionary? Any dictionary, or there must be an authentic dictionary? Authentic dictionary, which is more authoritative. Okay. Usually for English meaning, we talk about the Oxford Dictionary. Okay. If it is a Bengali word, which dictionary should you go? Yeah, Bangla dictionary, because that is the more authoritative dictionary for Bengali. Okay. So literal rule is simply the meaning of, you go by the meaning of words as mentioned in a dictionary. The understanding of judges, the reasons are very simple. Parliament used this word because they wanted us to go by the literal meaning. Judges felt that whatever the literal meaning of the word, that is what was the intention of the Parliament to apply. Okay. Now, literal rule, we have to understand there is a limitation of literal rule. What is the limitation? Limitation is, what if a word has got more than one meaning? Can we apply the literal rule? The answer is no. Okay. For you, for the application of your part C of your syllabus, remember you have to do a statutory interpretation. Always remember, if you think that there will be literal rule applicable, always remember you only apply literal rule if any word has got only one clear meaning. Although those who are the supporters of literal rule, they felt that no, even if it's not, you should apply the literal rule. But me telling you that yes, we only apply literal rule if it has got one clear meaning. That's the bottom line of it. Okay. If it has got more than one meaning, you will see literal rule does not work. If a word has got multiple meaning, okay, and you try to apply the literal rule, what will happen? It will lead to an absurd outcome. It will lead to an outcome which is not intended by the Parliament. You have to understand it. Whatever you apply, whatever meaning you find, that will have to be limited by the highest parameter. And what is the highest parameter? The parameter is the intention of the Parliament. That is very important to remember. Are we clear?
Yes, sir.
Everyone? We will see in cases that literal rule gave clear results. We'll see cases where literal rule did not give clear results. Okay. Golden rule is more like where literal rule cannot be applied. Golden rule is more like where literal rule leads to an absurd outcome. Now, this is something very important. You may have a word, listen carefully, you may have a word which has got only one meaning, one clear meaning, but if you apply that word according to that meaning strictly, it leads to an absurd outcome. So it is easier to remember. You apply literal rule when a word has got only one meaning, one clear meaning, but application of that one clear meaning, if that leads to an absurd outcome, do you apply the literal rule or do you apply the golden rule? You will apply the golden rule. So you can also say, you can also think that golden rule seems to be an extension of the literal rule, isn't it? Because you have got one word, one clear meaning, but that clear meaning does not solve our problem. It leads to an absurdity. In that case, do you apply literal rule or do you apply golden rule? You do not straight away go and look at golden rule. You first look at the, you see that this word pen has got only one meaning, but if I apply that meaning, it leads to an absurd outcome. What do? You apply the golden rule. If the one meaning gives us clear outcome, do you go to golden rule or you keep on using the literal rule? You keep on using the literal rule. Are we clear?
Yes, sir.
These two differences. Understanding mischief rule. The word mischief itself is mischievous, isn't it? What do you mean mischief? Okay, it's very easy to understand because you see, we have to identify a mischief in the act. Now, there is one simple formula where you pick it up and you know you need to apply no other rule but the mischief rule. The simple formula is if there is a statute in question which you need to apply, which you need to interpret, you see whether there is any other act before that statute. If there is none, if there is only common law before that statute, you simply apply the mischief rule. Okay. Let me rephrase it. If in any area of governance in a country, if there is only statutory law, if there is only common law, and the common law failed to give us any remedy, and to fulfill that vacuum, there is a statutory law. For the interpretation of that statute, there must always be the application of the mischief rule, not any other rule. Okay, that means the statute that you are interpreting, before that there was no other statute, there was a vacuum. The vacuum was filled by the common law, but common law actually failed to fulfill that vacuum. Okay, if you see a scenario like that there was no statutory law, there was only common law, you always apply the mischief rule. Okay, these three rules came to be applicable. Why? By whom? By the judges. Formulated by whom? Formulated by the judges. To make whose life easier? Their life easier, so that they can find out the intention of the parliament. Now, English judiciary has gone through major change. Major changes from 1973. Why is that year?
Because they ended the European Union.
Yes, from 1973, the legal system has started experiencing what I call the European element. Okay, there's a new dimension added to the English legal system. Okay, English judicial process, and that is the European element. And that has changed a lot of things. Okay, and that brought another approach of interpretation, and this is what we call the fourth approach. The fourth approach, what we call the purposive approach. Okay, it is not something originated by English judges. It is not something which originated from English judiciary. It is more like an imported element. Imported from where? Imported from the European main continent of Europe. It's more like a continental thing. Okay, that is the purposive approach. And in the process, in our next class, we will see. Once we are done with literal rule, golden rule, mischief rule, we will see there is a clash. Do we apply this one? Do we keep on doing them, or do we apply the what we call the purposive approach? Lord Denning was one of the biggest supporters of purposive approach. Those are the, well, this should be applied, this should be done. It took, English judiciary to accept it long time. Okay, not until Weber versus Hart. Okay, and there are restrictions after that as well. So the purposive approach is what we call the European element. There's another change very recently, a very significant change came in the English legal system in terms of interpretation of statute, and that came from the Human Rights Act. Remember we covered Human Rights Act, we looked at Section 3, Section 3 and 4. Section 3 and Section 4 brought, I would say, sea of changes in the way statutes are being interpreted by the judges. Okay, so it's very, very crucial that we revisit Section 3, Section 4, and actually get our understanding clearer, understanding of the interpretation process. And this is where you may face a question in exam from University of London, and that question is actually a comparison of literal rule, golden rule, mischief rule on one hand, and the purposive and HRA on the other hand. What are the changes? Okay, how they used to do them traditionally and how they do them now after the European elements came to play in English legal system. Okay, that's a very important thing we will face. More likely, the examiners more likely to examine your understanding about the changes brought by the European elements in English legal system. Are we clear? Yes. Okay, so in our next class, what we will do, we will examine literal rule, golden rule, mischief rule with reference to case law. Then we will look at purposive approach and Human Rights Act legislation, Human Rights Act of provisions, and with reference to common law, and we'll see how this is, how they have an impact. Are we clear?
Yes, sir. Yes, sir.
Okay. And in the process, we'll also have a look at few rules of grammar, and we'll look at what we call few presumptions. There are 6 presumptions about statute interpretation. Okay, those will help you to solve your problem questions. All right. Thank you.